Good morning to everyone. Madam Minister, would you please call the case?
Good morning, Your Honors. This is case IT 0992T, the prosecutor versus Ratko Mladić.
Thank you, Madam Minister. Mr. Mladić, if you're ready,
I am, Your Honor.
then please proceed. And I think the scheduling order said that you'll have 1 hour for
That is correct, Your Honor.
rebuttal evidence. Argument, I should say.
Thank you. Good morning, Your Honors. The defense and General Mladić reiterate that General Mladić never intended nor ordered any crimes and acted honorably at all times to defend his people and his country amidst a time of conflict. We emphasize that our thoughts go out to all those aggrieved. It is in this light, Your Honors, we would like to start by responding to the prosecution's use of the testimony given by RM-70. The prosecution has not provided evidence during their submission demonstrating that General Mladić knew about these wrongdoings or that they were reported to him. The defense points out that it has been proven that where General Mladić had knowledge of crimes by others, he always issued orders seeking to have perpetrators disarmed, arrested, investigated, and prosecuted. One striking example addressed in both the submission of the prosecution and the defense was in relation to the Arkan's Tigers in Sanski Most and the order to remove paramilitaries. There is no indication that General Mladić would act differently in relation to these wrongdoings. The defense notes that the prosecution cannot rely on RM-70's opinion testimony as being indicative of genocidal intent. RM-70 themselves highlights not all Serbs are the same. At transcript page 17,652, the witness quotes, "Because if there were, there hadn't been for some Serb, she wouldn't be sitting here today, because there are some good people among the Serbs." End quote. At transcript page 20,805, the prosecution invites the chamber to consider the 6 strategic objectives as indications of a common plan encompassing genocidal intent. The defense would like to stress that our position is the same as that of the Stakic, Krajišnik, and Sikirica chambers, which found no evidence this specific general political doctrine carried any genocidal intent. Furthermore, Your Honors, the prosecution's own expert, Robert Donia, acknowledged that General Mladić issued harsh warnings and expressed concern in relation to the creation of the 6 strategic objectives. At this stage, the defense would like to express its awareness of the Chamber's perception, communicated on 19 July 2012, that there might not be a factual basis for the bases of the knowledge of the intent of Mladić. I would now like to turn briefly to P431, the 16th Assembly transcript. At page 33 in E-Court, page 37 of the hard copy, General Mladić is quoted as saying, quote, "I would like to make one suggestion. Here that we adopt such a wisdom that we are against the war, but that we will fight if attacked. And we do not want a war against the Muslims as a people or against the Croats as a people, but against those who steered and pitted these peoples against us." End quote. Further, at page 35 in E-Court, page 39 in hard copy, General Mladić is quoted as saying, quote, "But that does not mean the Muslims have to be expelled or drowned. The minister would, it's a pity that we did not record it yesterday. To keep a long story short, as I said, they all gathered at my place, had a drink there, those from my village and from the neighboring village, both Serbs and Muslims. All must take care of one another." End quote. These fragments fly in the face of genocidal intent. Further, at transcript page 20,813, the prosecution itself refers to P431, page 49, which the defense has discovered is in error, as the text can be found at page 37 in the hard copy, page 33 in E-Court, and appears just before the text, the first text that I just read. And the prosecution implies that shifting the people from here to there is an organized campaign of ethnic cleansing, which is an interpretation completely out of context and irreconcilable with these remaining words which we have now drawn the Chamber's attention to. Yesterday, the prosecution submitted other personal statements and utterances of the accused as proof supporting counts in the indictment. We would recall the principle in dubio pro reo, which is applied to these, and also urge the Chamber to consider that these have been taken out of context as well by the prosecution. Additionally, Your Honors, the prosecution improperly made reference to events in 1991 and events relating to Croatia to attempt to establish the intent of General Mladić and to allege the commission of crimes attributable to him. This is at transcript pages 20,807 through 20,808. The defense reiterates that such time period and subject matter is beyond the scope of the indictment and has been repeatedly objected to by the defense. If the prosecution has not been able to establish criminal liability for the events occurring during the indictment, it is not permissible for it to expand the indictment period to include 1991 and Croatia without going through the steps necessary to give appropriate notice to the accused and to seek to amend the indictment. At the outset of their response, the prosecution at 20,803 of the transcript referred to police figures being members of the JCE. Your Honors, I remind you of those arguments advanced by the defense on Monday, relying upon the prosecution expert, Mr. Toynens, and the prosecution's evidence demonstrating that police were not subordinated to General Mladić and that he exerted all possibilities within his authority to apprise the police minister and Karadzic about the actions of the police and paramilitary units operating within the auspices of the police. This is again P3095, P5133, and P5065, among others. Moving along, Your Honors, at transcript page 20,817 and 20,818, the prosecution raised the notion that destruction of non-Serb cultural sites constituted evidence of genocidal intent and a genocidal campaign. The prosecution, however, did not include this in the indictment for genocide. If the prosecution tries to indicate that the chamber ought to infer genocidal intent from the circumstances surrounding the alleged JCE, they surely cannot rely on unscheduled incidents of destruction. Your Honors, the defense has, with great detail, outlined the evidence as to religious sites and their alleged destruction, and similarly, our concerns about the quality of the same, which we regard as incapable of belief. I will not say any more about this, except to point out that the prosecution did not offer any new or more detailed evidence on this topic to bolster the paucity of evidence that we brought to the attention of Your Honors during our submission on Monday. Further, at transcript page 20,803, the prosecution boldly asserts that the taking of UN personnel, which the defense did not raise in our 98 bis submissions, is indicative of the common purpose behind the JCE, constituting genocidal intent. Additionally, the taking of hostages is not properly pled in counts 1 and 2 of the indictment. As both the prosecution and defense have raised in our 98 bis submissions, it is well-established case law before the tribunal to apply JCE to specific intent crimes. However, in light of the lack of specificity in this indictment, this could have far-reaching and undesirable consequences to fairness to the accused and the development of future jurisprudence. In the briefest way, the defense will now address the the discussion of Directives 7 and 7.1 by the prosecution, which can be found at transcript page 20,835. The assertion was made that Directive 7.1 adopted the entirety of Directive 7. This is contrary to the plain meaning of the language contained in Directive 7.1, which was issued by General Mladić. Indeed, looking at P1470, page 2 in English, just above the tasking of the VRS, the only part of Directive 7 which is taken over is identified as additional details on the intentions and possibilities of enemy forces, which are said to be contained in Directive 7, and daily intelligence reports of the main staff. For the tasking of the VRS in Directive 7.1, it is said merely, quote, on the bases of Directive 7, end quote, and then the text proceeds to detail the tasking without reference to any of the controversial provisions of making life unbearable for civilians that are contained in Directive 7. Therefore, Your Honors, the prosecution argument as to this directive is factually misplaced. P1465, the Krivaya 95 plan, does not contain the language from Directive 7 directing to make life unbearable for civilians, and in fact, the text of the same contains no illegal orders. P1084, cited by the prosecution, is merely a map that General Mladić signed after the completion of Krivaya 95, and the map also does not contain any illegal orders to attack civilians. There thus is not available under this evidence any suggestion that the Krivaya operation and Directive 7.1 advocated any criminal intent or purpose. The position of the prosecution taken yesterday as to the Krivaya operation is contradictory to their opening statements at transcript page 486 and the conclusions of their own military expert, Richard Butler. Your Honors, I will move on to some other outstanding points. In relation to our arguments about the liability of third-party actors, the prosecution at transcript page 20,824 and onwards focused primarily on Prijedor and largely failed to provide counter-arguments or citations to evidence on the record for the remaining municipalities and locations that were the subject of our original submission. The prosecution spent considerable time on the command and control of General Mladić as to JNA infrastructure and equipment that became the VRS. The defense, for purposes of Rule 98 bis, did not raise command and control over the VRS as an issue for a no case to answer submission. Rather, we were very succinct and clear that the arguments as to command and control and effective control that we were raising related to non-VRS actors, including the police, paramilitaries, Arkhan's Tigers, and Scorpions. Thus, the prosecution's arguments are misconceived and do not rebut our submissions on this topic. The prosecution did briefly address the Scorpions, but misapprehended the defense submission. At this time, I would ask that we go into private session so I may discuss the testimony of a protected witness.
We move into private session.
In opposition, Your Honor.
Thank you, Madam Registrar. Ms. Mladić, could you at any point in time further briefly elaborate on what it is in the position of the prosecution taken yesterday that is contradicting what is found in transcript page 486? That's the opening statement. If you could do so,
Yes, Your
not
Honors.
necessarily immediately, but...
I can do so immediately. That
Yes.
might be easiest. In the opening statement, Your Honors, the prosecution indicated that the military operation directed against the 28th Division in Srebrenica enclave to stop the raids of the Armia BiH was not a illegitimate military action, saying that it was a legitimate military action. Their inference yesterday that the Krivaja plan for that operation demonstrated criminal intent is therefore, in the position of the defense, contradictory to their concession in opening statements that the military operation was not illegitimate. And that is the submission that I intended with that terminology.
I read on page 486 what the objective was, but then the prosecution added that Krivaja 95 had another objective that was anything but legitimate. So therefore, I'm trying to understand exactly how this contradicts where the prosecution has stated that it was not only a military action, but it was to attack Muslim civilian and UN observation posts, or OPs, in order to drive the Muslim population of the enclave into the small urban area of the enclave and create a humanitarian disaster. I'm just wondering whether this, I would say, twofold objective is contradicted by what was said yesterday.
It's contradicted by what is contained in the Krivaja 95 order, which I had
No, but
identified.
you are pointing at a contradiction between what the prosecution said on page 486 compared to what they said yesterday. That is what I'm trying to understand. Reading page 486 and having listened to what the prosecution said yesterday.
It was my recollection that they had said that the operation itself was not illegitimate, and what happened later that they claimed it was part of the second additional objective, I guess they called it, was illegitimate. And my point is that the additional objective is not to be found in the text of the Directive 7-1 by General Mladić or the Krivaja 95 attack order or the map as signed by General Mladić after the operation.
So your objection is mainly that the position taken by the prosecution is not supported by evidence, which is, of course, not the same as a contradiction between what they said in the opening statement and what they said yesterday.
Yes, Your Honor. You have said it much more succinctly than I did.
Thank you. Please proceed.
Nothing in the prosecution's submissions has rebutted the defense submissions as to the Scorpions. The prosecution at transcript page 20,853 has raised Kravica warehouse and has given a description of events at that location that are not supported by the evidence on the record. Rather, the chamber should look to the evidence of RM 374, a protected witness, who testified that there was a bus taking Muslims to Kravica warehouse, guarded by policemen on the bus. The Muslims on the bus overpowered the policemen and started exchanging fire from within the bus and with other policemen outside the bus. This is how one policeman was killed.
We're in open session, Your Honors.
Thank you, Madam Registrar.
Thank you, Your Honors. Madam Registrar. At transcript page 20,850 to 20,851, the prosecution has challenged only the qualification of Kingori as a principal witness for the genocide in Srebrenica, while demonstrating their position that he is merely very important for their case. The prosecution failed at all to address the conflicts between his testimony and several UNPROFOR officers that we believe renders Kingori's testimony incapable of belief. In relation to Škrivalieta at transcript page 20,831 and onwards, the prosecution asserts that the evidence demonstrated VRS officers intervened to have the perpetrators of the crime released from custody. The evidence cited does not support this proposition. P2371 is dated 10 September 1993 and is written on letterhead of the SDS Municipal Board of Sanski Most, not on behalf of any unit or formation of the VRS. This is a letter that is signed by the president of the SDS Municipal Board of Sanski Most and also by a captain who is a battalion commander in the VRS. Given the letterhead, it is clear that this is given in a personal capacity and is not an official VRS document. Further, the content of the letter amounts only to character reference and mitigating facts, whereas the letter seeks the military court to, quote, take this into account and pass fair judgment on him, end quote. The prosecution's case has collapsed. They can try to now expand the scope of the indictment.
May I interrupt
Yes.
a little bit? Did you say and pass fair or pass fair?
Pass fair judgment, Your Honors.
Fair.
Fair,
Okay.
F-A-I-R.
Oh, F-A-I-R. Okay.
Yes.
Thank you.
The prosecution's case has collapsed. They can try to now expand the scope of the indictment to try and demonstrate intent, and they can try to expand to have hostage-taking and destruction of religious sites bolster their case for concerted action between alleged JCE members. However, they have failed to explain how there can be concerted action between alleged JCE members, given the clear evidence on record of irreconcilable differences between General Mladić and SDS members like Karadzic, including the evidence that President Karadzic tried to remove General Mladić from his position and issued orders directly to VRS units bypassing General Mladić. The defense recalls Exhibit P501, where General Mladić is trying to find out who has instructed the Sarajevo Corps to use aerial bombs against Sarajevo, which the main staff did not order. Further, the prosecution has failed to demonstrate how there can be a meeting of the minds when Karadzic and Mladić differed and clashed as to their views on the use of Arkan and other paramilitary groups. In short, the prosecution theory of the case only works if one ignores half of the evidence, and this chamber must take the evidence as a whole. In our Monday submission, the defense briefly addressed exhibits P1547, P2141, P2142, D410, and P816, which dealt with prisoner exchanges and conditions. The prosecution has not presented evidence contrary to this. The defense implores the chamber to acknowledge that exceptions to the count-based approach are essential to uphold the object and purpose of Rule 98 bis. Having a presumption against acquitting the accused of individual charges within a count is one thing. But to remove any opportunity for this to occur goes beyond what is necessary to prevent the danger of a piecemeal application of Rule 98 bis. A blanket approach by the chamber offends the fundamental aspect of the rule's purpose: to give effect to ensure the accused is tried expeditiously and to uphold the requirements of due process, and allows the prosecution to exploit the count-based approach to disguise the evidentiary defects in their individual allegations, to adjudge and declare that the count-based approach should be applied to the present case in accordance with the jurisprudence is to confirm that 98 bis is nothing more than a paper tiger devoid of any practical application for the defense by virtue of the fact that trial chambers apply an overly restrictive interpretation of it. Before this tribunal, the Mladić Appeal Chamber stipulated that it is only appropriate to apply the notion of common purpose in relation to a joint criminal enterprise where the accused shared the intention to take part in a JCE and to further the criminal purpose of this enterprise. In addition, the accused must foresee the possible commission by other members of the group of offenses that do not constitute the object of the common criminal purpose. Paragraph 220 of the Mladić Appeals Judgment. Your Honors, the standard of Rule 98 bis is to determine if the defense has a case to answer. At transcript page 20,812, the prosecution claims a brutally efficient genocidal campaign occurred. No evidence has been presented to substantiate a general factual finding of genocide. Their own expert, Eva Thibault, presented evidence that emphasized there were only small differences in losses among the three warring ethnic groups. We strongly believe that there is no case to answer as to counts 1 and 2 because the prosecution has failed to demonstrate why by evidence capable of belief that General Mladić willfully entered the JCE with a common purpose, with foreseeability that others may resort to genocide to further that purpose. Lastly, we would invite the Chamber to consider the far-reaching consequences of including this many actors as sharing in the JCE's common purpose in light of the lack of specificity in the indictment. And with that, Your Honors, I again thank you on behalf of my client and my entire team for listening to our submissions. We have now completed our portion of the same.
Thank you, Mr. Mladić. Judge Mladić has a question.
Mr. Mladić, thank you so much. In light of the defense's objection to the prosecution referring to a period prior to the 12th of May 1992, how does the defense submit the trial chamber should interpret paragraph 5 of the fourth amended indictment.
If I can get access to the same.
I can read it to you.
If you could, Your Honor, that would assist.
Paragraph 5 says, Ratko Mladić committed each of the charged crimes in concert with others through his participation in several related joint criminal enterprises, each of which is described below. Radovan Karadzic and, as of 12 May 1992, Ratko Mladić were key members of an overarching joint criminal enterprise which lasted from at least October 1991 until November 1995.
Your Honors, the defense would ask the chamber to interpret the indictment as it is supposed to be interpreted based upon the notice jurisprudence. Here in paragraph 5, the participation of General Mladić is alleged to begin, his entry into the JCE is alleged to begin 12 May 1992. The schedule of the indictment, giving incidents for which it is alleged that General Mladić has criminal responsibility, have likewise focused on the time period post 12 May 1992. We have cited to jurisprudence relating to a JCE that indicates that the notice of a JCE needs to be specific as to the precise events alleged to be part of the JCE, the precise identity of perpetrators of the same, the precise manner of the accused participation in the same. And we would argue that given that the indictment, this indictment, claims to limit General Mladić's criminal liability as flowing from 12 May 1992 onwards, that this evidence that predates that time period, which has not been put in the indictment, should not be considered for purposes of the guilt or innocence of General Mladić.
Let me just make sure I understand you. The defense objects to the prosecution referring to actions of Mr. Mladić prior to the 12th of May. But the defense does not object to the prosecution talking about events by other participants which constitute JCE, which were committed before 12th May 1992.
That's correct.
Thank you very much.
Thank you, Your Honor.
Mr. Ivitic, I have two questions for you. The first one is that you referred to P501, where you said General Mladić is trying to find out who has instructed the Sarajevo Corps to use aerial bombs against Sarajevo, which the main staff did not order. Could you be a bit more precise where that exactly is found in P501?
If I can pull it up, Your Honors, I might be able to. My recollection was that the document reads, we have information that you are planning on using an aerial bomb against Sarajevo. Please advise us. Please advise us. I don't have the document here. How that has been issued, since the main staff is supposed to be issuing them. If the Supreme Command has issued an order directly, it should be sent to the main staff. That's my recollection of the document. I hope I have the right one.
Yes, that's perhaps what I wanted to verify.
Your Honors, perhaps I can, since we are done at the break, I can find that out.
If you can do that during the breakout, I'm looking forward to your answer. Then I have one other question, which is the following. You very much insisted on General Mladić never have given any inappropriate order. You certainly will remember that the chamber has listened to a intercepted telephone conversation in which the issue of engaging Mladić, where not many Serbs were living, was dealt with. Could you explain to us? Mr. Mladić would like to be consulted, but let me first finish my question without being interrupted. Could you further elaborate on how this chamber would have to interpret and have to look at such a telephone conversation and this observation about to engage Mladić where not many Serbs are living? If you want to consult before you answer the question with Mr. Mladić, then of course you have an opportunity to do so.
I would appreciate the opportunity to consult, and then I will attempt to answer your question.
Thank you.
Your Honors, after consulting with my colleague and the General and recalling that particular purported intercept, we remind the Chamber first and foremost that we have objected to the authenticity of many of the intercepts, and I believe that intercept as well. But to look at the content of the same, there is another meaning behind the same. Where the VRS attacks enemy formations in a particular location, if there are Serbs that live nearby, there is always the potential for reprisals against those Serbs by the ABIH forces. And so the intercept, if authentic, has an alternative meaning behind it that is equally reasonable under the evidence, and in the principle of indubio pro reo, the inferences must go towards the innocence of the accused. There is this meaning of limiting the ability of the enemy to undertake reprisals aimed against your own friendly civilians who may be in the area. And that would be the what I have to attempt to answer Your Honor's question.
Yes, then I would have one follow-up question, or perhaps rather to see whether we agree on a matter, which is that in this telephone conversation, if it is reliable, if it is authentic, that nothing is said about any military target in Mladić, but rather is talking about firing at Mladić. And if we missed something, that there was any specific military target mentioned elsewhere, so that we could understand this to be an indication of to engage that military target at Mladić, I'd like to hear from you.
My recollection, Your Honors, during the testimony when this was brought up, was that there was a discussion of when artillery plans are made within the Army, that specific locations are identified on a map, and that when communications are given, the common term is used rather than the precise location that would be known to those looking at the map together. That's all that I recall as being in the evidence upon this. We, of course, intend to present more during our defense case in chief, but that's irrelevant right now for 98 bis. But that's all that I recall as being in evidence. Your Honor is correct that the purported intercept itself does not give any more specific detail, apart from just saying Profalici, as to the intended target of the action. But there was, I believe, some evidence of maps having pre-coded targets included on them, such that commanders could refer using general terms, and those on the other end looking at the same map would know which target is intended. But I do concede that the intercept itself, as recorded, again, does not have any further specification apart from saying just Profalici.
And as far as other material is concerned, is there in the evidence to be found anything which specifically in maps or whatever way specifically refers to Profalici as being the location of any military target? I don't expect an answer right from the top of your head, Mr.
I could maybe also look at the break at that.
Yes.
Off the top of my head, I cannot think of any. The only map that I remember was related to another location, not to Profalici.
Yes. I think Mr. Mladić again would like to consult with you.
One moment, Your Honors.
Mr. Mladić, as you know, you're always invited to remain seated when you consult with counsel. Would you please sit down?
Gospodine Ori, ja ću da sednem, a mogu da razrešim ovo pitanje
I don't receive any English
i
translation.
pred vama i pred javnošću.
One second. I don't receive any English.
Can you hear the English now?
If there's anything Mr. Mladić would bring to the attention of the court, you may do so on his behalf. Without speaking, apparently consultation is over. Mr. Mladić, anything to add?
Yes, Your Honors. I would like to add what the General has just reminded me of, that his own home was in Profalici, and prior to this time period, the ABIH forces had engaged the local Serb civilians and had engaged in combat against them and had forced them out, and that his own home had been under fire and was burning and was seen burning by him in this area precisely at Profalici, so that there was a presence of an enemy force known to him.
I don't know whether this is to be found anywhere in the record, but
I
Mr.
don't know
Mladić is not expected to give testimony in his own case unless he presents himself as a witness and then be cross-examined on whatever he says. So therefore, in that respect, we'll ignore that as a piece of information, and you know how to have this information to be introduced into the proceedings. Mr. Mladić wants to consult again. I suggest that he consults with you during the break. We take the break, and if there's anything to be brought to our attention, we'll give you an opportunity to do so immediately after the break.
Thank you.
Mr. Groom, I'm just wondering, but I'm also addressing you, Mr. Mladić, whether we should take a break of 20 minutes or whether you would prefer to have the advantage of a little bit more time, not the same as between yesterday 2:30 and this morning, the time Mr. Mladić had available, but at least perhaps half an hour before we resume.
That would be appreciated, Your Honors, and I think our submissions will be less than an hour.
Less than an hour, and half an hour would be enough for a... Then
Yes, sir.
we will take a break and we'll resume at 11 o'clock.
All rise. Veuillez vous lever.